Good morning, everyone. This is Curtis Hawks, Chief Marketing Officer with Insurance Agency Marketing Services, and we've got a very special guest this morning, Mr. Chris Conroy. He's the Executive VP and General Counsel with IAMS. And today we obviously have a very important topic to talk about, which is the Department of Labor ruling. And we've had some new updates since the last time we spoke. In fact, that's part of the reason why we scheduled the webinar this week, is we had an inkling that the Department of Labor might finally come out with their additional guidance, which they ended up doing that actually yesterday afternoon. So we're going to be incorporating that into the presentation today. So I appreciate you taking some time with us. Before we get into the main topic of today's presentation, I did want to take a few brief minutes to chat a little bit about some of the additional ways that we can help benefit our advisors and help you with your practice. First on the list is our new producer builders, and as you can see up there, we've got a number of different options available to help our advisors. And this is really a great way, if you're not currently working with us, this is a great way to get going, test us out, get some production in, and then you can see with our point totals there a number of different options available that you can take advantage of. And I would encourage you, if you've got questions on that, certainly reach out to one of our sales directors. They can chat with you about how the point totals work. But it's a great way for us to meet you where you're at and help you to get to where you want to be. And the other thing that I would mention as well on here is if you're doing something currently right now that's working well for you, reach out and talk to a sales director. One of the core themes you'll find about us is that we have a very big focus on customization of services. So if you're doing something that's working well for you and you want to chat about how we can partner with you on that, certainly feel free to reach out and speak with one of the sales directors. You can reach them at 800-255-5055. In addition to that, we've got our IAMS Business Builders. These are a few additional great ways that we can help partner with your business. So one, if you're currently working with us and you like the service that we provide and what we're doing, our referred producer program is a great way to generate some additional revenue. Not only when you send someone our way do you get a $50 bonus when they get contracted, but then you get an additional $100 bonus when they write their first piece of business. And then I think this is a big differentiator, but on an ongoing basis, on a quarterly basis, you'll continue to get checks based off of their production. You don't have to do anything. We'll take care of all the service support for that advisor, but you get additional revenue coming into your business. In addition to that, we've got our marketing reimbursement program. As you can see up there, this is a great way to double the size of your marketing budget. For every $100,000 of indexed annuity premium that you do, we'll credit your account an additional $100, and we'll credit your account an additional $200 for every $100,000 of single premium life business or $10,000 of traditional life target. So if you've got questions on that, certainly feel free to reach out and chat with one of the sales directors over here. Back office support. It's an interesting topic. I think we've got one of the best support and service systems that you're going to find out there, but I think back office support was really highlighted over the course of the last year with the pandemic and with the carriers starting to have employees work remote. I think it got a lot tougher for a lot of advisors. And so what I would tell you is if you haven't experienced our back office support, you really need to. From case design, apps, licensing, everything on the front end, the team works very, very hard to do a good job. And then from statusing cases and making sure things get pushed through in a timely manner from submit to commission, I think we do a better job than most of the firms out there. So I would encourage you, if you haven't tried us out, you need to, and obviously certainly feel free to reach out and talk to one of the sales directors over here. Firelight, I did want to make a point on this. We've seen a significant increase over the last 12 months in e-applications, and so I did want to make a point that we do integrate with Firelight. We do have that on our website, and for that matter, we have iPipeline as well. So if e-applications are part of your business and how you do your applications, we've got a very robust platform available to you to be able to transact business. Next up, we've got creative marketing solutions, and I think creative has really been a core theme over the course of the last year. Many advisors had to pivot with the pandemic. Many advisors might have been doing different types of marketing strategies pre-COVID, and in getting into this, realize that those same things won't necessarily work the same way with the shutdowns and the various other things that we've experienced over the last year. And so we found that we've had to take a more tactical approach with the advisors that we're working with and get more creative on how to generate that consistent flow of prospects for our advisors. And so one of the ways that we do this is through our marketing analysis process. And with that process, what we're able to do is identify, what does your business look like? What is your target demographic? What are the marketing assets that you have? And then what do we think is the optimal plan to generate a consistent flow of prospects? And so I'm going to go ahead and launch our first poll question of the day. And this is a complimentary service that we offer. So I would encourage everybody, if you haven't taken advantage of this, you definitely need to. Also, we just wrapped up the first quarter. Right now is always a good time to look at, what is your second quarter goals? What do you want the balance of the year to look like? Are you on pace, and what adjustments do you need to do? And, that's really, I think, the end goal is to create balance in your marketing plan. And there's really three elements of balance. One is having a defined goal. Two is having a plan in place that you think will help you accomplish that goal. And then the third aspect is the ability to modify the plan. And we're able to accomplish all three of those objectives with this process. So I'll leave this up for a few more seconds here, but the nice thing about it is, once we do the initial call, give us a couple, 2-3 days. It's a relatively quick turnaround time. Your sales director will schedule a follow-up call, and then we'll go through what we think the recommendations are. So let me go ahead, and I'm going to close this down here. All right. Next up is our IAMS website. As I mentioned, we have a very robust platform. Not only can you do e-applications for life and annuity on there, but we also have illustration and quoting software for both annuities and life insurance available. You can access current rates on the site as well. If you're doing paper applications or need supplemental forms, you can download those. In addition to that, we have our sales resource library, which I think is a huge value add. And I say that because we've got a library that you have access to. If you're a licensed agent, if you're not licensed with us, reach out, talk to one of the sales directors about how you can get active with us and get access to the site. But we literally have several hundred different pieces that you can use on basically any topic that you would want to look at, whether it's annuity basics or life insurance basics, how does an IRA work, all the way to, you have somebody and you're talking to them about loan regime or economic benefit split dollar, and everything in between. And all optimized for whether you're going to meet with somebody physically or you're doing a virtual presentation. So it's a great resource that we've had our advisors using very, very frequently here over the last year. So in any case, I would encourage you, if you're interested in getting access to that, reach out, talk to one of the sales directors, and they can walk you through that. Next up, and we're very excited about this. We just at the beginning of the year announced our Top Producer Summit for next year. It is going to be a Mediterranean cruise. You can see up here, we're going to be working our way around the boot of Italy, and it really is designed to be an experience of a lifetime. Face-to-face time, being able to spend time with our advisors is very important to us. I think that's a big value that we bring, is trying to put together events like this. And so it was frustrating last year not being able to do that. And so what I would tell everybody is, there is plenty of time to qualify for this. Qualification period goes through June 30th of next year. It's 4.5 million points to qualify. And I would encourage you to reach out, talk to one of the sales directors over here. They can give you some additional information on it, but it really is going to be a high-end, concierge level experience of a lifetime, and just a great opportunity to get together with your peers and enjoy some well-deserved time off. So with that, we'll get into the main part of our presentation, which is on the DOL Fiduciary Rule update. As I mentioned, we've got Chris Conroy. He's Executive VP and General Counsel with us. For those of you that haven't had an opportunity to meet him yet, he has been doing this for over 24 years at the IMO as well as carrier level, has worked with over 1,500 reps of the top reps throughout the country, and so we're very pleased to not only have him with us, but going through this, but also as a part of IAMS. So, Chris, we appreciate you taking some time with us today, and looking forward to what you have to say.
Thank you, Curtis. We appreciate it, and welcome everybody. This is a topic. This is our fourth installment of the DOL Fiduciary Rule update, and it's a topic that we've had a record number of producers dial in for. So, as Curtis mentioned, very timely, because literally yesterday afternoon, the Department of Labor issued their much anticipated guidance in the form of FAQs. So we will sprinkle that in throughout this presentation, because I had a chance to review that painstakingly last night. And we've added some of the information about that throughout here. But yeah, this has been a hot topic. A lot of confusion out there. Just know that, IAMS is out there. We're here to try to provide clarity and real solutions is what it comes down to. That's our goal here, is to help our producers out there in the field continue to sell these great products that we offer, support their needs, and really be a leader for you behind the scenes here. A lot of misinformation out there, a lot of sound bites, incorrect information, limited amount of carrier information that's been distributed. We'll share what we have so far. This is candidly a pretty complicated rule. It's a federal regulation that's a couple hundred pages long. Today, we're going to try to keep it high level and get it into practical little pieces that you can dissect. So yeah, I will say this, and we've heard this from a lot of other agents out there, I haven't seen another IMO that's done anything like what we're offering, which is an update with a compliance kit, ongoing webinars, insights straight from DC. No one's doing that. And if you have an IMO or even your own broker dealer that's saying they don't know what the rule is, or you don't need to comply, you don't need to comply till the end of the year, I'd ask them to make sure that they're paying your E&O insurance. And I kind of say that tongue in cheek, but in all seriousness, they say, will you put that in writing? You don't have to do anything. They won't do it. And if they do, they're just flat out wrong. So that's clarified in the guidance we got yesterday. So let's move on to the next slide there. First, I just want to say we got your back. We're an advocate. I'm the immediate past chairman of the board for the National Association for Fixed Annuities, which is the exclusive trade group for fixed annuities, and indeed been out there lobbying, advocating for NAFA, advocating for IAMS, advocating for our independent advisors out there, so you can continue to have these great access these great products and really ultimately helping clients. So moving on to the next slide. So on the left there, you see that's actually a cover page of the Federal Register. So this rule, the fiduciary rule, as it's commonly referred to, was actually put in place by the Trump administration in December, after he'd lost the election, or seemingly he'd lost the election. And there was some news about, well, is this really going to go into effect? Because, change of administration, typically the new administration will take a look at the prior administration's rules and maybe bounce it. So literally everybody thought that this thing was going to get killed. One important point about this is actually a rule that's 10 years, maybe 11 years in the making. There was originally a fiduciary rule proposed back, I think it was fiduciary rule 1.0 back in 2010, and that was killed. It was proposed in 2015 under the Obama administration, and that was finalized in 2016. A lot of people in the industry remember controversial fiduciary rule that included that contract requirement, or the BICE, the onerous BICE. And that led to litigation, IAMS of which was a key part of that effort. And ultimately, the Fifth Circuit Court of Appeals blew up the rule, nullified the rule, and industry wins. Okay, so there was an overreach. The regulators had overreached what they had authority to do, and we kind of went back to the way it was pre-rule. Well, then there was in 2020, under the Trump administration, a new proposal 3.0, and that was finalized in what you see there, right, the Federal Register in December of 2020. Again, everybody thought it was going to get killed. We'll talk about, maybe we're headed towards the fiduciary rule 4.0 in the future, but that's the rule that was scheduled to take effect February 16. So go to the next page. And indeed, the Department of Labor, just days before February 16, announced that the rule would go into effect. You see an article there from Investment News supporting that. And so, a lot of people were surprised by it. Certainly NAFA, I was surprised. Everybody kind of expected that the new administration would just, what they could do is just unwind it and say, we're going to take a look at it again. So move on to the next page, Curtis. A lot of articles. What does this mean? One big notable thing is Marty Walsh, who we'll talk about a little bit later, was proposed as a Secretary of Labor, and indeed has been confirmed now. So there's a lot of noise about, well, what else is going on there? And, what does this mean? And now what? There's a lot of other things. There's the ESG, there's $15 an hour, wages, all kinds of things. But for now, the rule, was put into effect. And we'll talk a little bit about that in a second here, but moving on. So yesterday, new guidance comes out, and the Department of Labor had indicated back in February they would be working on some guidance, and we weren't surprised that they were in the form of FAQs, about 20 of them, and we can get you that resource. But there's a screenshot of page 1, goes on and on and on, adding on to a couple hundred pages of regulation here, and explaining what they're now saying under Biden administration of what that rule under the Trump administration meant. And it is like 6 or 8 trade pubs have already picked this up, a couple quotes from some industry folks, and that's an article there from Investment News. So indeed, we have this guidance. We'll sprinkle in some of that today. Moving on. It's important to note that there's, in the context of selling annuities, that really you got to jump through 3 or more potentially key regulatory hurdles. So there's the Department of Labor Fiduciary Rule, and this was the one, originally we talked about the Obama rule had been thrown out. We have the new rule, and then that affects, you can think of it in the context, what does that affect? Well, it affects all qualified money. Any qualified money of any sort, 401k, 403b, IRAs are all covered. Then you've got the SEC rule. So folks that are regulated at the SEC level, broker dealers, RIAs, they had to start complying with their new regulation best interest last summer. So you'd be familiar with all the rules that your broker dealer or RIA has been following to. And so that also could apply to in the context of annuities, depending upon whether you're supervised. And that applies to all reps and advisors. And then you have the NEIC, which is National Association for Insurance Commissioners. Think of it as revised suitability. It's also technically called best interest regulation model number 275. And we'll talk about that. That was finalized last year, and we've seen some states now adopting it and a lot of them intending. And that really applies to all people who are selling annuities.
So, Chris, just to be clear, because obviously we've had a lot of questions on this here over the last couple of months, but this new rule, this is a new rule. This is not the same. Somebody can't just, you should just go online and look for an old compliance forms, correct?
That's correct. Yeah, this is a new rule that we'll cover here in a second, 2020-02. While it looks kind of similar to some of the old stuff, and even the PT 8424 under the Obama administration, which was changed and then got killed in court, that old stuff doesn't work, unfortunately, and we'll talk about that a little bit, but it is new. So moving on there, Curtis, what you see is we can get you this updated. Actually, I think we have a version just from April 7th, but we have an updated, through a partnership with NAFA, updated chart of those states that have adopted or are in the works of adopting the new best interest or revised suitability regulations. So 3 states have adopted it, 21 are either have it, pending or working on getting something adopted. We can get you those requirements. Carriers are kind of sifting that info out, but we have a nice organized chart. We can get you that as part of our service here. The other big thing is available through IAMS is we saw this issue continue to materialize, and literally thousands of advisors have registered for our webinars. We said, boy, we better put together a toolkit. So we have a very practical, simplified best interest practices toolkit. We can get you that guide. Think of it as like a blueprint for what you need to do. We have that available through IAMS. Certainly, just ask for it. We can something that you can use to supplement what you're hearing today.
I'll go ahead and I'll launch our second poll for the day. If you are interested in getting access to that, go ahead and just flag that. And Chris, I would say, I mean, I even earlier this week I had an agent calling in. I mean, there's I think to the point you've been making, there's a lot of confusion with kind of combining these two things and having two big pieces of changes from a compliance standpoint rolling out in the same year. I think is a confusing thing, and making sure that you're doing the right things. And then I think you mentioned 22 states, I believe, with these NAIC regs that this is being impacted by.
Yep, and probably more to follow. Enhanced suitability, if you will, is going to continue to be an issue. So you want to make sure you're complying. Carriers have some information. We have the best intel that combines everything.
Yeah, absolutely. So I'm going to go ahead and I'll get this closed down here in just a second here. I think we've got everybody in. So I'll go ahead and put that. All right.
So moving on to the next slide, this is get into the guts of really what you need to know about the 2020 Trump rule and how this applies, and really in the context of annuities and life insurance, and how you make sure you're not running afoul of those federal rules. So first and foremost, it's important to note that what the Department of Labor did is really two things here. First, they reinterpreted, or what's called a final interpretation, in a 100-page defense of what they're doing, of how they've reinterpreted certain words. So you had the Obama rule, you had the Fifth Circuit Court of Appeals blow it up and say, nope, you overstepped your bounds. You had a new proposed rule, a new finalized rule, and in that finalized rule, there's a defense of what they're doing, which is kind of skirting the issues really, really close to the line of whether it's in compliance with the with law and the Fifth Circuit Court of Appeals. So in that 100-page final interpretation, what you see is the department moving towards a facts and circumstances type of approach to following the rules here. And what I mean by that is, certain words, like, and we'll get into the 5-part test a second here, of, what does it mean to have a primary basis of advice is given, by the advisor, or what does it mean that there is a intended recurring relationship? And so those words, which had a certain meaning back in 1975 when the original 5-part test was written, and kind of got changed with the Obama era rule, and the court pointed that out when it blew it up. They basically reinterpret what words mean. You think of it that way. And so you'll see that here in the final interpretation, that's really justified the broadened scope of who is a fiduciary. So for the longest time, even before the Obama era rule, most people selling annuities never even were within the scope of who would be a 5-part fiduciary test and be covered by this rule. So they need not comply with any Department of Labor rules. So they kind of defended what the broadened scope of who is covered, number one, in the final interpretation. And they've second reinterpreted what commonly is referred to as a 5-part test for who's a fiduciary. So those 5 parts, the classic things that come from a 1975 interpretation of who is an ERISA fiduciary, include 1, advice on securities or property; 2, providing advice on a quote regular basis; 3, pursuant to a mutual agreement between the advisor and the client; 4, that the advice is the primary basis for the plan or the recommendation to take action on the plan; and then 5, that the advice need to be individualized to the needs of that particular client. So for the longest time, before the Obama rule, a lot of advisors selling annuities never met one or maybe all of those requirements, primarily of which was that people didn't provide ongoing advice to the customer about their annuities and in a context of a regular basis pursuant to any kind of mutual agreement. It just didn't apply. In addition, there was actually what's called an advisory opinion, the Desiree letter, which was rescinded. There's more of that in our toolkit, but that was rescinded in connection with that final interpretation. And that talked about, in the context of an IRA rollover from a 401k plan to an IRA, a one-time recommendation isn't covered as a fiduciary advice. So the Department of Labor actually unwound that, said, we're going to pull that opinion letter, which they can do, and we're going to reinterpret these words, and we're going to broaden the scope of who's really covered. So the impact of that is really that the Department of Labor in 2020 has now tried to thread the needle, basically cover everyone who's working with qualified money no matter what. And that includes recommendations to roll out of qualified plans like 401ks, 403bs, et cetera. So that's the Trump administration's PTE, which you kind of say, well, why would the Trump administration do that? And that's a little bit of a surprise to the industry. They kind of, took the pieces that they, in their opinion, were illegal as found by the court in 2018, and really kept most of the guts of what was under the Obama administration's rule, which was largely the industry did not like. So what you have here is you don't have the contract requirement. We'll get into the guts of this in a second. You don't have the contract requirement of the Obama administration's fiduciary rule, but pretty much everything else is in there. And it's broadened the scope of who is a fiduciary for ERISA purposes. So that's number one. The other thing is, where do we stand? There's what's called PTE 8424, which our toolkit goes into very detail about, which is, you think of it this way: if you're going to sell a qualified plan or you're going to work with a person's qualified money in any context, you need to have what's called a PTE. It's short for prohibited transaction exemption. So in regulatory parlance, what this means is that if you're going to get paid anything, any compensation for advice that you render to somebody, it causes them to take an action, do an IRA rollover, sell a plan, make advice that causes a person to really do anything with their qualified money, you have to, if you get paid, getting paid is prohibited, hence a prohibited transaction. However, if you have a PTE, a prohibited transaction exemption, then you're not in violation of those federal rules. So it's this kind of labyrinth system. But the point here is that you have one of two pathways if you're selling annuities and rolling money into life insurance. And those two are PT 2020-02, the new one that Biden administration has let go into place, and then the existing 8424, which we'll talk about. So you have to use one of those two, otherwise you're violating the federal rules. The last point is just about the the Biden administration priorities. And so, indeed, this is a priority. I don't know that it's a front burner issue. I think, obviously anything related to COVID, $15 an hour minimum wage is probably a bigger issue right now. However, the fact that the guidance had just come out yesterday indicates that, enhancing consumer protection for retirement dollars is a priority. And so I think, we were a little surprised by the delay, but we're there now.
Well, do you think that, in your opinion, do you think that's the deal for why there wasn't a delay on this ultimately, and they let it go through?
Yeah, good question. A little bit of speculation based on talking to some insiders. I think some of it is the incoming administration say, you know what, let's let something stay on the books. Frankly, it was surprising the industry how much teeth that the Trump administration rule had, and they said, well, let's just let it go on the books, and we can always go back and revisit it, which is probably where they're headed, as we'll talk about.
Okay.
So moving into the kind of the components of this, what you have is, again, the 2020 version is a lot like the Obama rule, which was, had the best interest contract, except for the contract requirement. A lot of the controversial stuff was there. The financial institution requirement, having a supervising entity that oversee you, is still kept there. We'll talk about that in a little bit. And then you have the 8424, which keep in mind, this is, as we just talked about, is different than the Obama 8424, because the Obama administration actually did change what the scope of that was in the application. So just keep that in mind. The Fifth Circuit Court of Appeals ultimately blew up that rule, the revised Obama version, but just keep in mind that is not valid if you're trying to just do a Google search for 8424. That pathway is much easier, as we'll talk about. It's a simplified disclosure regime, and it really works only for insurance or annuity transactions, we'll talk about. Number three, so there's really just one of two pathways to comply. You'll hear some noise. We certainly heard it from many advisors who've talked to other IMOs that, well, it doesn't really apply unless there's, quote, a non-recurring relationship. Well, the department, and particularly with the guidance that they've provided just yesterday, clarified that even a one-time advice to roll somebody from, you know, roll into an IRA can and often will be fiduciary advice. So really the idea of like oh, hey, I gave you advice, Curtis, and you know what? It's a one-time sale. I'm never ever going to talk to you. I'm never going to call you. I'm never going to do an annual review. Which is just totally impractical. That doesn't work. And certainly the way they painted the rules in these couple hundred pages make it clear that that's just not really a practical exception. Maybe in the context of like, I sold you a SPIA and I'm never going to talk to you again. But you know, Curtis, I you know, as being a good customer of mine, I'm probably going to talk to you every now and then. And the last point here is about what's called the Department of Labor Field Assistance Bulletin 2018-02, and we'll cover that in a little bit. What that is a reference to a temporary enforcement policy. So for those that want to jump through the PT 2020-02, which is much more onerous, as we'll talk about, than the 8424, you still have to adhere to the impartial conduct standards. And what does that mean? We'll cover it a little bit, but if you're doing nothing, then that's not compliance. So moving on to the next step there, you know, the nuts and bolts of this thing. So really, first of all and foremost, again, reminder, all qualified money is covered, all advice is covered, and it's kind of a subjective reinterpretation of that 5-part test, which the best we can tell, and certainly talking to a lot of top ERISA lawyers, there's not really a way to wiggle out of saying you don't meet the 5-part test. Because of the broad scope of how the Department of Labor has interpreted that. The core of this whole rule is rooted in the concept of what's called impartial conduct standards. And that's really the bedrock expectations of the Department of Labor. It kind of comes from the concept of being a ERISA fiduciary, which is like a trust fiduciary. And the core of that, you know, the real focus we'll talk about is managing and eliminating conflicts of interest, the core one of which is compensation. And then fees, focus on fees and kind of doing right by the client ahead of your own interests. So the best interest standard there's 3 components really of impartial conduct standard. First of which is best interest. So serving the best interest of the client. The 2 core components there from a legal perspective is prudence and loyalty. So there's the legal standard of a prudent person. So prudent person, a prudent advisor in a like capacity with kind of the best interests of the client in mind. What would you recommend for that person? And you need to have a full understanding of their picture and also have a good understanding of what all those options are out in the marketplace. The second is loyalty. And again, you have an advisor has to have putting their the interest of the client ahead of their own at all times. So prudence and loyalty are the bedrocks of that best interest standard. Now, reasonable comp is the second piece, and you know, it's interesting, not really specifically defined there. If you look at what that means or how they've interpreted it, and look at a lot of the ERISA lawsuits in the past, it's a market-based factor. So looking at the market as a whole for similarly situated products, given the complexity of the product, the unique features of it, the length of time you're going to support that client, even the reference to guarantees embedded inside an insurance product like an annuity is a component that can be factored into reasonable comp as kind of a reason to justify a comp. And it also, keep in mind, includes all compensation. So the duties on the advisor here, in some cases financial institution, in the case of 2020 rule, but having to factor in all compensation. So the extent you're actually getting paid by, I don't know, an IMO or some other, you know, a bonus, a supplemental thing, then that has to be factored in, and that also has to be reasonable. Third is no material misleading statements where you kind of say, well, so what? I don't lie to the customer. And that's true. The key there is to disclose all the features, limitations of the product. And the department clarifies that even omissions or not stating certain things that would be important for a investor to know about could be also a misleading statement. So being complete and also being truthful throughout is kind of the guts there. Now, here's where I'll weave in the guidance that we read from last night. So the guidance here in talking about how do you meet kind of the best interest, and when you think of it in the context of I don't know, taking a look at somebody's 401k plan. Should you roll that into an IRA? You're better off. You got more choices and so forth. So what the department has clarified in their FAQs from yesterday is you got to look at the old plan, all of the options, all of the fees, the costs, and do that in comparison to the new recommended products that you're going to recommend. So what are the fees, costs, limitations? Ultimately, what's the client paying and what are they getting? New versus old. And you have to look at their existing lineup of products in the entire menu. And then with that, they said, you know, you might consider that you have to leave them in the plan, number one. Number two, you need to look at the fees and expenses of the plan versus the IRA that you're looking at. And you might need to consider if the employer is paying some of the plan expenses. And then last, take a look at the services and the investments that are available under the old existing regime and what you're recommending. So there's a real focus here, the department's clarified, around fees, commissions. In some contexts, it might be better to sell a commission-based product over a fee-based product. And for those of you, that's another point of confusion. I think some people say, well, I'm a fee-based advisor, it doesn't apply to me. That's not true. Absolutely not true. Because think of it from the context of an advisor who's recommending somebody to roll out a plan. If you're getting paid anything, and you are getting paid fees, fees are covered. That means you have to have a prohibited transaction exemption because that fee is prohibited, a prohibited transaction. So you still have to jump through those hoops and you have to be able to justify that what you're recommending is better and is serving their best interest. You got to take a look at the long-term impact of the costs that are associated with what you're recommending. In particular, in the context of fixed annuities, the department clarified yesterday that you should consider surrender schedules and caps and rates and other features of the annuity, and how does that compare to what the expectation with the current lineup would be. The last thing of note, and again, this is guidance from yesterday, is that the department clarified you need to go ask that client for, imagine a 401k plan, what are all those different investment options? What are the fees associated with it? You might need to go look at Form 5500s. You can't just kind of stick your head in the sand and say, I didn't get the information from the client. That is not going to meet the standard here. So moving on to the next page, you know, with the 2020-02 rule, a core component of it is an acknowledgement in writing that you are a fiduciary and your financial institution is a fiduciary. So that's a differentiation from the 8424 process. Policies and procedures, which your financial institution supervising entity can be one of four. There are four approved financial institutions. That would be a broker-dealer, an RIA, an insurance company, or a bank. And they would be the supervising entity that's also on the hook for compliance with this, and you'll have their own conflicts of interest that they need to manage. Ultimately, they're the entity that's going to be creating policies and procedures. So those folks that are on this call right now that are reps, some advisors that are supervised, you know, all of their activities are supervised, maybe even their annuities, their fixed annuities are supervised. We have some broker dealers that's the case. They're likely to have their own SEC Reg BI compliance. This is supplemental to that, and in many cases, actually additional liability to the firm. And so expect to see new policies and procedures rolling out from your firm. If you're not sure, call them. If your CCO doesn't know what you're talking about, call us because we can help you with that. But the guidance on this conflict of interest mitigation is really important one. That's really one of the core issues that the department identifies as a potential problem. And one of the core conflicts is compensation, meaning the advisor getting paid, the financial institution getting paid, and recommending something that is not ultimately in the client's best interest, kind of putting your interest ahead of them. So incentives, in particular, the guidance that came from yesterday talked about, you really says you really need to discourage the idea of selling a particular product over another product, or even having a volume-based incentive, meaning you hit a certain GDC or number of annuity sales, then you get a retroactive perk or benefit. They really frown upon that. They really frown upon proprietary or limited venue products that can generate third-party fees, which is not uncommon in the industry. the idea of quotas and retroactively paying. Once you get to this level, I'll pay you more retroactively is an item that they called out as being a problem that would create a conflict of interest. Talked about maybe you could use a gradual comp increase on a prospective basis only. And the other big thing, and this for folks that are with a broker dealer or an RIA that are on this is much different than the SEC Reg BI, because in that context, largely the firm, the supervising entity, is not on the hook for differentiated comp. Under the Department of Labor's fiduciary rule, you are on the hook, which means the department makes a point of that, is there can be a conflict of interest created to the extent that, say, a broker dealer is making more money on a particular mutual fund, ETF, I don't know, annuity, security sale, whatever it might be. To the extent you're getting more for a similarly situated product, that is a conflict of interest that needs to be mitigated or eliminated. The other stuff on guidance, it talked about insurance companies in particular, and if they choose to use this 2020-02 rule, which none of which have, and how they could potentially supervise their ultimately independent advisors. The key there is to try to avoid incentives, financial incentives to sell one particular annuity over another, and even made reference to, the insurance companies to make sure it's not creating a system that would make it, quote, most lucrative for the insurance company. So whether that can be followed, we're not sure. Certainly insurance companies, having worked at one, that can be a challenge because, like any product line, you're going to have some things that pay you more than others. And then they make reference to how IMOs and BGAs potentially can be a resource there in helping the advisor serve the needs of the agent, in particular in the context of third-party comparisons. So, as Curtis mentioned, kickoff, we have a, top-notch annuity sales director team and back office. We have lots of tools where we can do those comparisons, product line to product line, and kind of ultimately help the client in what the best recommendation is. And the department made a note of that, is that third-party comparisons, having a good look at what's across the industry is really, really important here to make sure you're complying. And then other quick things is documentation, record keeping. So there's a duty under this 2020 rule of a long record keeping and documentation process that's got to be kept in case you ever get audited, and a retrospective review that's done by one of the top officers of your supervising financial institution. So moving on there, Curtis.
So one quick question I had too before we get into the next section is just listening you go through this. I mean, who do you think would actually be most likely to actually use this pathway?
Good question. Broker dealers and RIAs are largely going to be using it. I suppose banks, but in the context of annuities, if you're with a broker dealer that supervises indexed annuities today, they probably would use this, and they would probably, kind of bootstrap it on their SEC Reg BI. Many, I'd say, in fact, most by count of broker dealers do not supervise annuities because they're not securities, they're insurance products. So potentially broker dealers, insurance companies, I think it'll prove very, very difficult to do this because of the nature of our business, with almost all the sales being from independent agents who work for multiple companies, multiple IMOs, multiple products. Things change. It's kind of impractical. It's to think, and they don't traditionally supervise like in the context of a FINRA broker dealer.
Okay.
So the other pathway, as I mentioned, you got to have a PTE or prohibited transaction exemption in order to advise and get paid anything on the sale of qualified money with a client. And so the first one we talked about, which is trying to do a condensed 200-page rule there, is a lot. It's very onerous. It's difficult. Indeed, large institutions are scrambling with their lawyers trying to figure this out, comply with it. It's different than Reg BI. It's supplemental. It's a challenge. The other pathway that's available and only for insurance and annuities is a reference to prohibited transaction exemption, PTE 8424. 84 references 1984, which is when this original rule came out. On the left there is an excerpt from the preamble to the 2020 rule, which the department clarified that it said it is important to note that insurance and annuity products can also continue to be recommended and sold under the existing exemption for insurance transactions, PT 8424. So that one is available. On the right there is actually page 1 of that rule, which we'll talk about here in a second. So it is available, as you'll see, is frankly much less onerous to comply with because it's a disclosure-based regime. And the other thing, and I'll move on here, is the footnote 4 to the guidance that came yesterday also clarified that 8424 is available for people to use. So it has been reaffirmed now under the Biden administration. So the guts of 8424, it's a disclosure-based regime. It's a simplified form. We've created one. We'll show you in a second here is a one-page form. The key components of it are, one, you have to disclose the relationship that you are an agent for the insurance company. And if there's any limitations, so maybe you're limited to just that one company. Number 2, you have to have reasonable sales commissions, fees, or other consideration. So there is that reasonable comp kind of context, and that's in light of all the marketplace for reasonable comp. Look across the industry, other similarly situated products. Is that reasonable in light of what you're doing, and also kind of benchmarking other products that are out there? Number 3 is disclosing comp. So this is different than even the NEIC model, which says that the client has a right to ask for comp, but you actually have to put the specific percentage first year in any renewal compensation that's earned as a result of that transaction. And then there's a reference, you have to describe the charges, fees, penalties, or any adjustments. So you'll see in our form, and what can work there is a reference to all the other disclosure documents that a client would get in connection with the sale. So moving on there, Curtis, we have a compliance guide for 8424. This is the fiduciary rule summary here. Talk about the history, the 8424. This is available. The compliance guide is a good reference supplementing what we're talking about today. I'd encourage you, to ask for that. We can get it to you. It's, kind of a, 4 or 5 page long summary, and gets you the key points.
Yeah, I'll go ahead and I'm going to launch our third poll. If you are interested in receiving that, go ahead and fill the form out, and we'll make sure that we have one of the sales directors get that out to you. I think another point, and I think we're going to throw this up on the next slide, but this also includes the 8424 form as well. Is that correct, Chris?
It does, yes.
Okay. And I know you're going to be getting into this here in a couple of slides, but I think an important point on this is we've got this compliance track. Agents need to talk to one of the sales directors. I know you're going to be covering a couple of different questions on filling out the form, but it is important to make sure that not just that you're filing it, but that you're filling it out correctly as well, correct?
Yeah, that's true. Yeah, you'd want to have a conversation with the director just to know what it is and how it works and how you save it. We can keep it here as a record keeping requirement. We can keep it here. For sure, talk to a director. Yep.
Okay. So I'll go ahead, and I think we've had most everybody fill that out. So we'll go ahead and close this down, and then get you over here, and then I'll let you take it from here.
Sure, Curtis, thanks. So we created a compliance form here. Encourage you to take a look at it yourself, or I don't know, go visit with a lawyer if you need to. But the core components of this, and you can look at the regulation, but the core components are included here. And this meets the requirements, and we have that available. That's something you need to have signed by the client, dated. You actually don't have to give it to the client, but you have to keep it yourself. Carriers generally don't want this form back. That may change. At this point, no carrier has wants this or wants it back. You do have to keep it though, for record keeping purposes for 6 years. We have a repository here. We can keep it and make sure you're meeting that requirement. News. So, people said, well, what are carriers saying? Well, for a while there, they didn't know what to say because it was a surprise that the rule took effect. American Equity went first. Athene went next, and then North America just last week came out with their piece and video from our friends there. So we made a reference to it, and notably in each of those, I highlighted the section there. None of those carriers said they're willing to do the 2020-02 version. They basically say, yeah, PT 8424, which requires a simple compensation product disclosure and is applicable to insurance annuities, it's really the pathway. And you know, American Equity, we're not intending to use it. Athene 8424 seems to be the most likely exemption to be used for some situations. Athene will not be utilized in the 2020 rule. And same thing with North American, is that it just doesn't fit with independent producers. And so at this time, none of those carriers, and we expect, I know talking to a couple of other carriers, in the coming week, maybe two, you're going to see more carriers do the same thing. And so they're really steering in the context of annuities towards the 8424 process. Moving on there, Curtis, you know, kind of highlights of the guidance. Again, ran through this last night. One, they confirmed, number one, the rule is in effect. It was in effect February 16th, you know, and you know, we had a webinar. This is our fourth one. I think we had one right around then, and with a record number of attendees. So it clarified the rule is in effect. There is a lot of confusion about what does that mean, you know, who has to comply. We tried to cover a lot of that today, and we also have that compliance guide. They also confirmed that rollover recommendations do trigger ERISA fiduciary advice, in which you need to have a prohibited transaction exemption, either the new 2021 is kind of complicated, or the 8424. Third, you know, they made a point of focusing on differentiated comp and incentives, and that can create a conflict of interest. So for a similarly situated product, say a mutual fund or an annuity, similar annuities, really the idea of getting paid more is going to create a conflict, which seemingly would suggest that it's that would be a prohibited transaction. Robust documentation. So, you know, this in the context of best interest. So how do you meet best interest standard? How do you know whether you're serving best interest? Well, you got to look at all those things of what their current lineup is, and the context 401k. There's a lot of information there, and you need to be able to document all that. And ultimately, if you're going to use the 2020 rule, you know, your supervised financial institution is you're going to be required to put that in writing and give it to the client. So, you know, they clarified that's a expectation with that rule. The long-term costs of the plan, and so think of the context of rolling a 401k to an IRA and putting an annuity in there. The long-term fees and costs, which it may very well be far better off with the annuity, but be able to document that out and understand any limitations that might come along with surrender charges or fees and commissions, et cetera. It needs to be documented and considered in the whole context of this rule. They also clarified that, you know, insurers can in fact use 2020-02. You know, I think they just reiterated some of what was already in the 200-page rule from before. In practice, I think that's going to be difficult for many carriers. I know they're going to try to scramble and see if there's any way to do it, but not hearing any carriers. I think there's, you know, a little bit of the writings on the wall, though, that that perhaps they should seriously look at whether there's a means to do so, and that they could look at their lineup of products, but still have to meet this idea of best interest in light of all the other products that are out there. So that's a tough one. I think carriers are struggling with whether that's feasible. The three carriers have already publicly said anything, said that they're not going to use 2020-02. They did affirm that 2020 is available. 8424 is available for now. And they did also make, there's a quote, continuing to review issues of fact, law, and policy related to the exemption. And more generally, it's regulation of fiduciary investment advice. That's kind of a fancy way of saying, you know what, we're going to take a look at this and we might rewrite it. We might rewrite 2020-02. We might rewrite 8424 potentially. So it's kind of up in the air at this point. And so how that process would work, practically speaking, is they'd have to send out a notice out to the public and say, hey, we're thinking about change of rule. Here's what we're thinking. Provide comments. Now, generally, the regulators probably already have in mind what they want to do, but they have to legally do that and make it available for everybody to make comments. So moving on, Curtis, to the next slide, predictions. So on the left there, you know, you got Congress. There's no crazies like storming the Capitol today in that picture, but It is possible that there could be legislation that gets kind of ramrodded through here. Could be bootstrapped on a big package that would provide additional, legislative authority for the regulators to change the rule, make it more difficult, make it easier. So that's a possibility. Haven't heard much news about that, but it's not uncommon for some kind of thing like this, kind of retirement consumer protection type of rule to get bootstrapped onto something. So we're watching that closely, but that's a possibility. In the middle there, that's actually Marty Walsh. So Marty Walsh is the now Secretary of Labor. He's a former Boston mayor, kind of an old-fashioned labor Democrat, really heavily involved in the trades and so forth. Seen as a progressive, I think he is, pro-consumer, but also practical, I think, and seeing what's going to work. I think there's a big priority at the Department of Labor right now around, things like the ESG regulation, anything with COVID, obviously, OSHA, consumer protection, employee protection type of, activities out there. There's, $15 minimum hour wages are big ones. This one, the fact that the guidance came tells me, it is probably pushed up as a higher priority than some may have thought. But ultimately, Marty Walsh, and he'll appoint an EPSA secretary, that's the Employee Benefits Security Administration secretary, and that staff, largely a lot of the career folks that are there are, many of which are from the Obama administration, are still there. So kind of the workings of the team that could come up with a new rule or enhanced rule or whatnot are there. I think it's whether it's a priority, and I think it could very well be a priority, given that they're pushing this out now just 2 months after the rule was affirmed. And then third is that's the Supreme Court. So while the Obama rule was killed in the Fifth Circuit Court of Appeals, never got to the U.S. Supreme Court, and it's conceivable that this rule could end up back in litigation, or a revised rule could end up there, and we'll kind of have to deal with all that transition compliance as we need to. We'll get that information out to you. So those are really the three core branches. I think there is a real chance that with a enhanced rule that kind of steps beyond the bounds of what the Fifth Circuit Court of Appeals says, I think there could very well be a legal challenge. I don't know whether that's successful. I don't know. But as written, even the Trump rule, many believe probably gets really close, or maybe goes over the line of what was permitted by law. So move on to the next slide there. I know we just got a couple minutes, and I'll hit through the questions real quick. Just know this: we have a disclosure form. The 8424 can work for you. We get you more information. Encourage you to talk to directors here. We have that state best interest. That's the revised suitability chart. We get you information there. We'll continue. We've been talking about this in newsletters for a year now. And we got fourth webinar, thousands of advisors that are dialing in for it. We have that back office team that's as good as any in the industry, access to a lot of tools and support to make sure you're meeting best interest requirements. And then we'll help you with the carrier requirements as that news comes out, and making sure you get whatever their requirements are. And then quick questions. I'm going to rifle through these pretty quick because these are hot ones. I know, Curtis, we got. First of all, are withdrawals to fund life policy covered? Yes, they are. So if it's coming from qualified source and you're getting paid anything, you need to have a prohibited transaction exemption. So our compliance form does work for life insurance as well, but that is covered. Number two, I got a supervising firm. I'm with a broker dealer. I already do Reg BI. Isn't that good enough, or quote a safe harbor, meaning you do that and it kind of de facto complies? No, it does not. It is the Department of Labor said that specifically in their preamble, is that it is not a quote safe harbor pathway. Same thing with an agent on Model 275. So if you comply with the new 275 best interest revised suitability, isn't that good enough? The department answered that question too. They said no, it's not. So you still got to jump through this additional hurdle at the Department of Labor level. Number four, okay, well, I want to do 8424, but I got split agents, sub agents, who has to comply? You really need to have anyone who is sitting down and getting, with the client and getting paid. So if they're advising the client and they're getting paid anything, they need to have a compliance form there. So in theory, it could be on one form if it was, I don't know, 50-50 split, something like that, as long as the total compensation is disclosed. But indeed, anybody who's advising the client and getting paid needs to have a compliance pathway. Number 5 is, are the carriers going to send out new infos? Is this a new rule on them or just me? So, we've seen 3 carriers. I suspect we'll have several more here in the next week, just given with the new guidance out. This is a rule that if you use the 8424 pathway is really not on the carrier. And so that's, I think, largely why they're kind of steering you to use 8424. It's going to be really hard, I think, for a lot of carriers to do 2020-02. And while 8424 is sitting out there as a pathway, it seems like a good logical solution. The other part is if you are with a regulated entity like a broker-dealer or RIA, they may be going the 2020 route. In fact, they're going to have to with regard to all the other products that are out there because 8424 is only for insurance. So they have to have their own compliance pathway. They may very well say, use that 2020-02 for everything, including insurance. Who would enforce this? So some people, oh, who cares? I get sued. Well, a couple quick things there. One, if it's a rollover from a 401k plan, say a rollover to an IRA, that would be Department of Labor. They have authority to regulate that. They also have authority to regulate, transactions that are interpret the revenue code for purposes of compliance with PTE. So the Internal Revenue Service would actually be enforcing violations of IRA to IRA transfers, but they would be using what the Department of Labor has put in this couple 100-page rule. So it'd be IRS, and they could potentially blow up the tax deferred status of that IRA and include excise taxes on top of that for violations, meaning if it wasn't within their best interest, you didn't meet all the compliance requirements we talked about today. In addition, new guidance, and maybe we kind of knew this before, but the department in their guidance yesterday said that under Title I of ERISA for plan rollovers to IRAs, the consumer would also have a private cause of action under Section 502 of the ERISA plan. So if they think you didn't meet the requirements and you breach your fiduciary duty, you could get sued by the client and or their beneficiaries of that IRA plan. And then last is, could this be changed? And the answer is yes. The regulators have broad authority to change what they want. They got to jump through the Administrative Procedures Act, well as notice and comment and so forth. They've done that before. They're very familiar with it. Doesn't mean they couldn't potentially be violating the APA and other requirements. However, they do generally have the right to modify. And that's kind of what they tip their hat, I think, a bit, is they're going to be seriously looking at changing it, which means the industry is going to be in there lobbying and saying, don't do this, don't do that. But, we could live with these kind of changes. Curtis, I'll flip it back to you then.
I appreciate that.
Wrap it up.
Yeah. And I appreciate you taking the time to do a really in-depth overview on this. So a couple of things here. I'm putting up our social media pages. We are on a weekly basis posting updates, not just on Department of Labor, but all things going on in the annuity and insurance and industry space. I would also let you know too, we do record all of our presentations and put them on YouTube as well. So, make sure to like and follow us online. Lastly, and again, I know we covered a lot of material in a short period of time. In fact, I think we ended up going over here a couple of minutes, but hopefully what you took away from this is a change, but we've got a very, very good, effective pathway with the information and tools you need to make sure that you're in compliance and can continue to do business and focus on core elements of what you're doing, which is prospecting, marketing, onboarding new prospects, and not having to worry about being out of compliance. So with that, again, if you've got questions, feel free to reach out to us. Phone number is 800-255-5055, and we appreciate you spending some time with us today. And Chris, thanks for taking the time to go through this as well.
Yep. Thank you, Curtis, and thanks everybody for joining today's program.